Lordships have put is whether you can club 3 plus 4, etc. can be done or not. That's the second issue, additional issue. So please first now take 124. 124 2, 124 minutes 3.
Yes.
A person shall not be qualified for appointment as a judge of the Supreme Court unless he is a citizen of India and A, has been for at least 5 years a judge of the High Court, B, has been for at least 10 years an advocate of a High Court. I mean, rest is not so relevant. Then let's kindly come to explanation 2. In computing for the purpose of this clause, the period during which a person has been an advocate, any period during which a person has held judicial office not inferior to that of a district judge after he became an advocate shall be included. Then let's kindly come to explanation 2. Can this explanation, which is for the purpose of computing the period for which a person has been an advocate, which is under 124(3)(b), can we read a similar provision for 124(3)(a)? No, because it's not there. It's not there, so you can't read it, number one. Number two, it is equally clear that the sources, both sources are clearly mentioned. And the third, of course, that he should be a jurist. That's we are not concerned with that here. But the sources which are there, number one. Number two, we can't say, your lordships will not interpret and say that a person 5 years as a judge, he can be 3 years a senior advocate, etc. You can't, because that's not the explanation. It's not said there. Now kindly come to 217. 2172. A person shall not be qualified for appointment as a judge of a high court unless he is a citizen of India and A, has for at least 10 years held a judicial office in the territory of India, or has for at least 10 years been an advocate of a high court or 2 or more courts in succession. Now let's kindly first come to AA, explanation AA. In computing the period during which a person has been an advocate of a high court, there shall be included any period during which the person has held judicial office or the office of a member of a tribunal post and so on. So after he became an advocate. Now A is introduced by the 44th Amendment in 1978. And A, now I will place A, explanation A. In computing the period during which a person has held judicial office in the territory of India, there shall be included any period. I'm placing explanation A,
Yes.
In computing the period during which a person has held
judicial office is that whenever the Constitution wanted certain period as an advocate or as a judge to be included, the Constitution has specifically provided for the same in 124 and 217, and that cannot be read by an interpretation in 233(2).
And that, I'm so obliged, and also all the sources are explicitly stated. The sources are explicitly stated. It is not for conjecture that not already in service implies in service.
So they all explicitly say so. Therefore, what we are telling you is that there is no need for the argument because Rameshwar, they have clearly.
I agree, Malaz. It was now kindly
see. Your own manner.
Kindly see. I'm placing additional issue 2. I'm reading the issue, Malaz. Whether a person who has been civil judge for a period of 7 years or has been an advocate and civil judge for a combined period of 7 years or more than 7 years would be eligible for appointment. This combined cannot be done, Malaz. Number one, it can't be done because there is no explanation. Now, Malaz, ancillary to this.
And also, or issue number 4 is the same.
I'm reading issue 4, Malaz.
Yes.
This is issue number 4. So, Malaz, if my lords are in agreement that explanation for clubbing, etc., is not permissible here, Rameshwar Dayal and the language, then issue number 4, Malaz, which has been the fulcrum of the discussion here, is clearly, Malaz, answered there. And not only here, we are in a far we are on a much stronger footing. Why? Because here the Constitution is not even referring to them directly, Milind. We are understanding not already in service, therefore there is a service, and whether that service contemplated in 233(2) is referable to 1 or should be read into 2, and then we say no, he can be 7.